and thank you for joining us for our introduction to the Public Interest Disclosure Act webinar. This presentation covers some key messages about BC's Public Interest Disclosure Act, also known as whistleblower protection legislation. We first want to acknowledge with respect that we are presenting today to you on the traditional lands of the Lekwungen people and ancestors, so the Esquimalt and Songhees First Nations. And the work of the Office of the Ombudsperson, of course, extends across the homelands of many different Indigenous peoples within what we now call British Columbia. So we honor the many territorial keepers of the lands and the waters where we work. Welcome again. So this webinar today is intended to provide a really high-level overview of PIDA and to speak to some of the key roles under the legislation. We also want to introduce you to a number of resources that our office has developed for public bodies to really help them understand their roles and responsibilities and to assist them with the implementation of PIDA. Going to start with some very brief introductions for myself and my co-presenter. So my name is Jennifer Jones, and I manage the Office of the Ombudsperson's Public Authority Consultation and Training team.
Hi, everyone. My name is Lindsay Hunt. I'm the Learning Specialist with the Office of the Ombudsperson as part of the PACT team with Jennifer.
Great. Okay, so diving right in, what is PIDA? It is, broadly, BC's whistleblower protection legislation. And what is whistleblowing? Basically, it means that an employee or a former employee can raise concerns of wrongdoing from within their organization. And the definition of wrongdoing under PIDA is covered in an upcoming slide. Well, what is it that PIDA does? What does PIDA do? Well, what it does is the Act carves out an exemption to the general common law duty of loyalty that employees owe their employer by creating these different pathways for employees to disclose confidential information to allow them to report wrongdoing. And so employees in the context of PIDA can include permanent, part-time, temporary, or auxiliary employees, and it also includes co-op students, but it doesn't include certain roles in an organization such as contractors or volunteers. The Act also provides protection from reprisal or retaliation for those employees who do speak up about wrongdoing, and it also includes confidentiality protections. Only employees and former employees in sectors and organizations that are covered under PIDA can disclose wrongdoing under the legislation and access the protections that PIDA provides. It's also really important to note that there's no time limit under PIDA for making a disclosure of wrongdoing. Therefore, it's important for organizations to be prepared for issues to surface that may date back several years. And part of having a really good system in place to respond to these disclosures is knowing how to conduct a good assessment from the start to determine if PIDA applies. And the first step in this is to determine whether the allegation would give rise to the definition of wrongdoing under the Act, or if it should be dealt with under some other existing mechanism. For example, under some standards of conduct, perhaps a human resources investigation or internal audit. So what's the purpose of PIDA? Well, having public interest disclosure legislation, it promotes accountability, integrity, and confidence in the public sector. It ensures that there's a really safe way for employees to speak up when they see something happening in their workplace that's wrong. And it's a way to address problems before they become bigger and more complex. PIDA was ultimately introduced in response to a recommendation that the Ombudsperson made following his investigation into employee terminations at the Ministry of Health. And if you're interested in learning more about that investigation and public report, we would encourage you to review the misfire report that our office released in 2017. So PIDA came into force in BC and in December of 2019, and uniquely, rather than an en masse application to the public sector, in BC, PIDA was rolled out to most public sector organizations in 7 different phases over a 5-year time period. And when the Act first came into force, it only applied to employees and former employees of BC government ministries and independent offices of the legislature. However, beginning in April of 2022, the Act began to be rolled out to the wider public sector. Okay, so what is wrongdoing under PIDA? Wrongdoing has a very specific meaning under PIDA, And wrongdoing under PIDA is really serious misconduct that is in the public interest, not just in a person's interest to address. So there are 5 types of wrongdoing defined under PIDA, and they are as follows, and as you can see on the slide. So the first one here is a serious act or failure to act that, if proven, would constitute an offense under an enactment of British Columbia or Canada. So essentially, this means something so serious that it is also illegal. Is something serious happening at the workplace that would be deemed an offense? The second type of wrongdoing is an act or failure to act that creates a substantial and specific danger to the life, health, or safety of persons or to the environment, other than a danger that is inherent in the performance of an employee's duties or functions. So for clarity on this, a substantial danger means a serious danger likely to result in real harm, and this includes extreme damage or threat to the environment. And a specific danger means that there's an actual threat and something or someone is at a particular risk. So the danger is identifiable and expected at a foreseeable future date. It's important to note that this type of wrongdoing does not include danger that is a normal or expected part of a person's job. So the third type of wrongdoing is a serious misuse of public funds or public assets. In other words, a use of public money or assets that is not authorized or approved, that is illegal or not in line with the relevant legislation, regulations, policies, and procedures. Next is gross or systemic mismanagement. It's another category of wrongdoing. So put this another way, mismanagement is the inappropriate or irresponsible management of a government resource, such as staff, a contract, or a project. And gross has a similar meaning to serious. So systemic mismanagement means mismanagement that is broad, long-standing, recurrent, or inherent to the organization's culture. And this fifth type of wrongdoing, as you can see on the screen, is directing or counseling a person to commit any of the above. Okay, so what does a disclosure mean when we're talking about wrongdoing under PIDA? So the purpose of a disclosure is for employees or former employees under the jurisdiction of PIDA to report wrongdoing. And if someone goes through with that process of reporting wrongdoing, they are making a disclosure. The form of a disclosure must be in writing. So this might be in the form of an email or a letter. Your organization might develop a standard disclosure form for people to fill out. If someone needs help putting their disclosure in writing, assistance should be provided by the organization. And the content of the disclosure, it must include the following. So it should have a description of the wrongdoing, the name of the person or the public organization who is alleged to have committed the wrongdoing or about to commit the wrongdoing, if that's known, the date of the wrongdoing, also if that's known, and whether there is another mechanism or avenue that the employee or former employee is obliged to report under. And if so, what mechanism is it, and has it already been reported through that avenue, and to whom? An employee or a former employee can choose to disclose wrongdoing under PIDA in the following ways. So there's a choice reporting model. Employees can report wrongdoing internally to their supervisor or designated officer. Each organization under PIDA needs to ensure that they have procedures for managing disclosures in place and that at least one senior official is designated as the organization's designated officer before the implementation date for that organization. Employees or former employees can also disclose wrongdoing to the Office of the Ombudsperson of British Columbia. And employees don't have to exhaust any internal complaint mechanisms before reporting wrongdoing to the BC Ombudsperson. And again, there is no time limits on reporting wrongdoing. Also, under some very limited circumstances, PIDA allows for reports of wrongdoing directly to the media. And these are for instances that pose an imminent risk of serious danger to the health and safety of people or to the environment. And employees can make a public report of wrongdoing only if prior approval has been received from protection officials. So this means either the provincial health officer, the provincial administrator under the Emergency or Disaster Management Act, or the police. So there are many different protocols to follow, and so getting advice on this or visiting the Ombudsperson website for information is really important if an employee is considering this particular reporting pathway. So we often use the phrase speak up culture when we talk about PIDA. And what is a safe speak up culture? Well, research shows that employees want to believe that the leaders in their organizations will hear and address their concerns. They really want to believe that they work for an employer who will do the right thing and take action to correct wrongdoing. And the success of a good speak up culture is about people feeling safe, comfortable, and confident in bringing forward something that they believe is wrong and knowing that there's a process in place to respond to it. So they shouldn't feel scared. It shouldn't feel like a monumental undertaking. Speaking up about wrongdoing should be normal and encouraged. And some of the factors that enable employees to come forward include all of these things here on the screen. So feeling safe and believing that coming forward is consistent with their employment duties rather than being a disloyal act. It's important for employees to understand the process for reporting wrongdoing, to know that concerns will be taken seriously and thoroughly investigated. And they need an organizational culture where the act of speaking up is really normalized and accepted. And this last one about normalizing speaking up, it's really about creating a listen up culture. So ideally, leaders will demonstrate that concerns expressed by staff are not only welcomed, but encouraged. And it's really important to be inquisitive and curious and listen to what isn't being said, as well as what is. So we're going to provide an overview of the protections for employees under PIDA next. And these protections really support employees in being able to speak up about wrongdoing. So whistleblower protection legislation is generally aimed at providing a very clear pathway for people to speak up and to encourage them to do so. And BC's Public Interest Disclosure Act does this by offering a number of key protections. And the first key feature of PIDA is the confidentiality protections that are provided to employees who disclose wrongdoing or who seek advice about reporting wrongdoing. And confidentiality is a very important piece to public interest disclosure because it's essential that organizations put processes in place that protect the identity of employees who raise their concerns as much as possible. Confidentiality is very important because it protects employees from reprisal, which we'll discuss further in a moment. It also keeps the focus on the issue and not the disclosure. So we must never reveal the identity of the disclosure in an investigation, and instead we should focus on the issue of concern. And this allows organizations to focus on the problem or the wrongdoing and in the public interest in fixing it, as opposed to focusing on who reported the matter. And it also encourages employees to speak up about wrongdoing by creating a safe environment where their identity is protected. So the second key protection for employees and former employees under PIDA is reprisal protection. In other words, they are protected against facing retaliation in the workplace for reporting wrongdoing. And reprisal protection is triggered by doing a protected act. And protected acts under PIDA include making a disclosure, seeking advice under PIDA, or cooperating with a PIDA investigation. So for example, someone responding to an investigator's information request or a witness in an investigation, they're cooperating with an investigation, and any retaliation against them for doing so could be considered reprisal. It's important to remember that reprisal can come in many forms. It can be discipline, a demotion, a termination, bullying within the workplace, exclusion, spreading rumors, undermining an individual's credibility, basically anything that adversely affects someone's employment or working conditions. Also, reprisal isn't just about what a manager or a supervisor might do. It can also come from an employee's coworkers or their peers. And it's also very important to remember that only the ombudsperson can investigate reprisal complaints. So that's where those types of complaints should be directed. And this is different than disclosures of wrongdoing, which can be made to and investigated by the organization or by the ombudsperson. Lastly, important to know that reprisal is also an offense under PIDA and is therefore reportable to law enforcement. I'm going to pass things over to Lindsay now.
Great, thanks. So we've covered the key protections under PIDA, so the confidentiality protections and protections from reprisal. So we're going to turn now to look at the different roles and responsibilities under PIDA. I'm going to pop a list up here. So you can see here on the slide the roles for individuals under PIDA. And as you can see, there are specific and different roles for chief executives, designated officers, supervisors, and also for employees. I'm going to go through the roles of chief executives, designated officers, and supervisors, and then in more detail in the next few slides. And then I'll touch upon the roles as it pertains to employees as well. So there are a number of expectations for chief executives. Some of these are legal requirements under the Act, and some are best practices. Chief executives must appoint at least one senior official as a designated officer for giving advice and receiving and investigating disclosures within the organization. They must also develop procedures for managing disclosures. These are called Section 9 procedures. And I'll note here that model procedures are actually available from our office. And these procedures include things like setting timeframes for reviewing and investigating disclosures, assessing the risk reprisal of to disclosures, protecting the identity of disclosures, and reporting investigative outcomes. It's essential that these procedures meet the legal requirements under PIDA and reflect investigative best practices. This includes ensuring a fair and impartial review of the issue reported and making sure that those impacted have an opportunity to respond to the concerns under investigation. Chief executives also must ensure that all staff within your organization are well informed about PIDA, including how to make a disclosure, both internally or directly to the Office of the Ombudsperson, creating awareness of PIDA and what it is for, and also where to find more information if needed is a key role here. And it's important to make your information and processes accessible for all employees through various formats. So this can include things like posters or emails or other communication streams. Another responsibility is to ensure that all staff within your organization are well informed about reprisal. So what is it? And also to know that there's no adverse measure, such as termination or demotion, that can be taken against an employee because they sought advice or made a disclosure or cooperated with an investigation. Of course, always important to remember that reprisal is an offense under the Act. Another responsibility for chief executives is to ensure that supervisors and designated officers are equipped to receive disclosures that are made to them by employees. Chief executives must publish an annual report that provides information about the number of disclosures received and how they were handled by your organization. It's also important to develop a method for tracking the number of disclosures received and investigations completed for the purposes of this reporting. And then it's important to foster that safe speak up culture within your organization for employees to voice their concerns and to report wrongdoing. Make sure people in your organization know about the importance of speaking up when they see something serious that they believe needs to be addressed in the public interest. So that's an overview of the responsibilities for chief executives. We're going to move on to the expectations for designated officers. Some are repeats from the previous slide, but we'll go over those. And just also want to note that some of these are legal requirements under the Act and some are best practices. So designated officers must understand their role with respect to giving advice and receiving and investigating disclosures within the organization. So making sure that they have that training and have reviewed the resources available, including those provided by the ombudsperson to assist this aspect of their role. Designated officers must ensure the confidentiality to the greatest extent possible of all employees that approach them for advice or making a disclosure or cooperating in an investigation. They must take disclosures they receive seriously and thoroughly assess them. Designated officers, you're undertaking investigations of disclosures in accordance with PIDA and the organization's procedures. They also have a responsibility to contact the ombudsperson to consult about the investigation of a disclosure or with questions about requests for advice. So there's that option for them. Consulting with the Office of the Ombudsperson is a legal option under PIDA. They assist chief executives to ensure that all staff within your organization are well informed about PIDA, including how to make a disclosure. And then they also ensure that all staff are informed about reprisal. And then they have that role as well on around fostering a safe speak up culture within your organization for employees to voice their concerns and to report wrongdoing. So we'll talk about supervisors here now. There are a number of expectations for supervisors. And again, I'm going to say it again, some are legal requirements under the Act and some are best practices. So supervisors must understand their role with respect to giving advice and transferring disclosures to the designated officer. So that's, you want to make sure that supervisors have taken the training and reviewed all resources available in order for them to be able to do that. Supervisors must ensure the confidentiality of all employees that approach them for advice or to make a disclosure. This includes not discussing the identity of disclosures with others in the organization. Supervisors also, they take requests for advice and written disclosures seriously. They transfer disclosures to the designated officer immediately. They make sure that accurate records of conversations are kept and that they're stored securely and separate from an employee's regular human resource information. They also have a responsibility to contact the designated officer or the ombudsperson with questions about requests for advice. So during this process, it's not necessary to share the details of the request and to not share the identity of the employee, but this really is around reaching out with questions. Supervisors must ensure that staff who approach them are well informed about PIDA, including how to make a disclosure, both internally or directly to the Office of the Ombudsperson. And it's around creating that awareness of PIDA, what it is for, and where to find more information if needed. And then also ensuring that staff who approach you are well informed about reprisal as well, what it is, and that no adverse measure, such as termination or demotion, can be taken against an employee because they sought advice or made a disclosure or cooperated with an investigation. That's around making sure staff are informed about how to disclose, which I already spoke to, sorry. And then lastly, this is around fostering that safe speak up culture as well. So that's a responsibility across the board for everyone. So when it comes to employees, their role, as it was laid out in that initial slide, their role really is to seek advice and disclose wrongdoing. Um, and it is the role of the supervisors, the designated officers, and chief executives to ensure that employees know how to do this. Our office, primarily through the Public Authority Consultation Training Team, has developed a variety of resources to assist organizations to fulfill responsibilities under the Act. And so, with that in mind, we've developed a course specifically for employees who are covered by the Public Interest Disclosure Act. It is called Speaking Up Safely. So this e-learning course, it's available for anyone to register for. It's free and it can be found at learn.bcombudsperson.ca. And upon completion of this course, learners will be able to identify serious wrongdoing according to PIDA within their workplace. They'll know who they can seek advice from on issues relating to PIDA. They'll know how to report wrongdoing and also reprisal complaints. They'll understand the reprisal and confidentiality protections provided under PIDA, and they'll understand the role of the ombudsperson and the choice that they have when it comes to disclosing wrongdoing. If you're a designated officer, we've created a designated officer toolkit to assist you in your role, and this is available on our website, bcombudsperson.ca. This toolkit covers all aspects of managing disclosures of wrongdoing, from assessment through to report writing, including how to complete a PIDA investigation. It flags PIDA's specific investigation protocols and provides general investigative best practices to assist with procedurally fair investigations. Included with the toolkit are a number of standalone assessment tools, guides, and templates to assist with all aspects of assessing disclosures, planning investigations, conducting interviews, and then writing investigation reports and more. As an accompanying resource, we've developed an e-learning course, and this really goes hand in hand with the toolkit. And it's called Designated Officer Fundamentals, and it takes you through the designated officer key roles and fundamental information needed to provide advice and receive disclosures under PIDA. And again, you'll find that e-learning course on learn.bcombudsperson.ca. So other resources that have been created and are available on our website include a pre-recorded webinar covering the responsibilities of supervisors under PIDA and numerous written resources for chief executives, designated officers, supervisors, and employees. So some examples of these written resources include confidentiality tips for supervisors, guidance for small public bodies, chief executive responsibilities, and a PIDA frequently asked questions document. So that's just naming a few of the documents available. And these are all downloadable from our website, and we encourage people to access them and share them. So before we end our presentation today, we do want to highlight our office's role under PIDA. Our office has a varied role under PIDA, and we've touched on some of this earlier, but here's a quick review of what we can do. So we can provide advice to employees considering making a disclosure or reprisal complaint. The Act provides that union representatives or lawyers, the person's supervisor or designated officer can also give advice. Our office can assist with an investigation or part of an investigation. The office also supports organizations in the development of policies and procedures in the implementation of the Act to their organization. Our office investigates disclosures from former and current public sector employees in a fair, effective, and timely manner. Included in this is a very thorough assessment process that is undertaken before investigating to ensure the allegations meet the threshold for wrongdoing and to determine whether there are reasons why the office cannot or should not investigate. Unlike the organization, we can only investigate if the allegations could constitute wrongdoing under PIDA. Our office investigates reprisal complaints. So the Office of the Ombudsperson is the only body who has jurisdiction to investigate reprisal complaints under PIDA. And lastly, if an employee or former employee discloses wrongdoing to the Office of the Ombudsperson and it is investigated, at the conclusion of an investigation, the office will issue an investigative report containing any findings and recommendations and provide it to the head of the public body. So we want to just take a few moments here to acknowledge that in 2024, we released our first public report on a whistleblowing investigation. We just want to provide an overview on that. So this report related to hiring practices for temporary assignments by the BC Public Service Agency, which is the centralized HR agency for the BC government. Temporary assignment positions strengthen the knowledge and skills of the public service and better prepare employees to fill permanent positions. As such, these development opportunities are offered to public service employees who have already competed for their existing position under the public service's merit-based hiring process. And so for these reasons, the PASA has a policy that prohibits ordering council or OIC appointees from applying for temporary positions. OIC appointees are government employees appointed by cabinet. However, for more than 10 years, OIC appointees could apply for these internal temporary assignment positions despite not being eligible. And as a result, 64 temporary assignments were offered to OIC applicants who were not eligible. This occurred because there wasn't a way to screen these applicants out. And an unwritten process was developed to facilitate the hiring of OIC employees if they were successful in a job competition. This process was developed for administrative convenience. It was easier than fixing the screening process. And as a result, regular public servants lost out on career development opportunities. And we found that the PSA's conduct represented systemic mismanagement of the internal temporary assignment hiring process. And we made 4 recommendations to correct this issue. So, why does this investigation and report matter? Well, 64 public servants lost out on career advancement opportunities from 2013 to 2023. Um, undermines the public service's commitment to employee development, and it impacts public service's reputation as a fair employer. So, if you want to find more information on that report, and the recommendations that we made, we do really encourage you to read through it. It's available on our office's website. We'll just pass it over to Jennifer to wrap up here.
Great. Thanks, Lindsay. So that concludes our presentation, and here is contact information for you to reach out to the BC Office of the Ombudsperson for assistance. So if you're looking for specific advice about a disclosure or about how PIDA fits into your existing policy framework, you can certainly contact the Public Interest Disclosure Team at report@bcombudsperson.ca. If you're looking for additional educational resources, email the Public Authority Consultation and Training Team, that's our team, at consult@bcombudsperson.ca. Thank you so much for your time today.